Thank you, Adan. Thank you, all of you, for being with me this evening. And as you can hear, I have a very bad cold, so I hope everything works well with this presentation. And I have to apologize for speaking in English to you and not in this wonderful language of Spanish. I try very hard to learn it, but I do not master it sufficiently to give this presentation in Spanish. Now, my topic today is not only about artificial intelligence. I was so glad for your presentation of all these myths of artificial intelligence, that artificial intelligence will solve all our problems, and that's definitely not the case, and I'm so thankful for your presentation. Thank you so much. And this is another reason why I want to talk about cybercrime compliance a bit broader picture. First of all, compliance. As a criminal scholar, my focus will of course be on criminal compliance, not on civil law compliance and other forms. And I only care about committed compliance, not about fraudulent compliance, not about creative compliance, about committed compliance. And speaking of cybercrime, I've already mentioned it, I want to address the topic of cybercrime from a more broad perspective, crimes where artificial intelligence is used, I will talk about that, but also about other forms of crimes against information technology and of crimes where information technology is used. And why is cybercrime compliance such an important topic? First of all, cybercrime is an evolving threat. Yesterday, we had a very large blackout in Argentina and Uruguay, which might have been caused by cybercrimes, which might have been caused by other causes. Cybercrime is an evolving threat. And I will try to show in my presentation, cybercrime is not just one additional topic. Those interested in compliance have to look at beyond corruption, environment, and all these other topics of crime. Cybercrime is something different. Cybercrime is something which leads to a transformation in the field of compliance, not only because of these new tools we have in the digitalization of our society, but because cybercrime might actually be something a bit different. So that's why I think that cybercrime compliance deserves a specific spot here in this course. Now, the theory I want to explain to you today, or my idea, maybe you think this is nonsense, but then please tell me so later on. My theory is that we have 4 degrees of cybercrime compliance. What's the first degree? That's the classic view that compliance is about the compliance of the corporation itself. It's about the agents and the organs of the organization that they do not commit crimes. And in relation to cybercrimes, it means that agents and organs of an organization are compliant in relation to cybercrime laws. What does this mean in particular? Well, there are certain data protection requirements, there are certain requirements regarding intellectual property, which need to be addressed in relation to this first degree of cyber compliance, but that's not really something new. But do we see something new here in relation to new systems involving information technology? For example, self-driving cars. Well, we do have some new legal challenges we have to solve. For example, when programming a self-driving car, we have to tackle the so-called dilemma situations, where this if such a car determines, I am in a dilemma situation, if I just drive on, I will kill 4 people, if I drive to the left, just 1 people, and to the right, 2 people. Where shall this car go? That's a topic which is highly discussed, And it relates to compliance, as in the production process of such a self-driving car, such rules must be implemented correctly. But in the end, in my view, there's too much theoretical discussion on this topic and too less practical discussion. For, of course, such a car has to drive in a way that it does not get into such a dilemma situation at first. That's the very basic training point we have to think about. Then others, legal scholars, they will try to determine, okay, the person on the left, he's 80 years old and he's so sick that he will die within the next year. To the right, you see two people who are very healthy. So it's, of course, much more sensible to kill the 80-year-old man who will die anyway in the next year. A self-driving car will never have such an information basis in a situation where it ran out of control anyway. And even if it had such an information basis, it would just be probabilities and not certain facts. And therefore, much of the discussion on this topic is headed into a wrong direction and based on a myth that technology can indeed solve everything. In the end, and there's a very good article published just a couple of months ago in Germany on this topic. In the end, we should stick to our principles of criminal justice, our principle of criminal philosophy, and not to try to put too much trust into technology. And in relation to artificial intelligence, for the time being, and also about self-driving cars, it's important to understand what artificial intelligence can actually do today. A self-driving car will never ever get the idea, okay, today I would like to fly instead of drive. A self-driving car will always be limited by the features it got by its producers. So it will only be able to drive at a speed of, let's say, 150 kilometers per hour, and it will never have the chance to drive even faster. The intelligence embedded in such systems is limited and will be limited forever, at least for the foreseeable future. And what we have today is so-called weak artificial intelligence, where the training is done in a controlled circumstance and under the control of the producer, and just then the implementation is handed out to the customers. And for that, we have a very clear framework. We do not really have a problem of causation, we do not really have a problem of attribution. Artificial intelligence does causes much less problems than we think. We do have some interesting theoretical discussions about so-called strong artificial intelligence, where a computer system really gains superhuman capabilities in all sorts of behavior, but that's fiction, that's science fiction, that's also legal fiction, that's not the legal problems of today and of tomorrow. So, in the end, I would say compliance, cyber compliance in the first degree is something we can address with our classic theory. It's mostly about classic questions and challenges. Now to the second degree. Cyber compliance has since long been extended to cover the behavior of all employees of a corporation and partially even to the supply chain or to other natural or legal persons in the vicinity of the corporation. And same as with the classic compliance programs, we might have to distinguish between crimes committed in the course of a business activity or merely at the opportunity of a business activity, and whether a crime was committed against the corporation or at least also against other persons. Now, what's the problem? What's the distinct issues of cybercrime, of the digitalization in this field of compliance to the second degree? Well, in terms of the digital life of today, it's a bit harder to distinguish what actions, what omissions are private, what actions, what omissions are business related. Today it's far more common to check one's personal emails also while conducting business, so the borderline between private actions and business related activities get blurred. Furthermore, information technology, and that's really the specific point for cybercrime compliance in the second degree. Information technology might offer a great tool for compliance, especially when it relates to available persons. The more persons you need to keep under control, the more useful information technology with its optimization, with its scaling will have. And there another catchword comes into play: blockchain and blockchain compliance. And again, we would need Professor Miro to give a presentation about the myths of the blockchain. In the end, the answer is pretty similar to artificial intelligence. The blockchain is useful, it has its useful tasks, but you should not trust it blindly. You should ask specifically, what do you trust? Who do you trust? Do you trust the programmers more than the lawyers? Do you trust the technology more than human people? It's a matter of trust, and it's about assessing the risks associated with blockchain. Just to name one example, smart contracts. Who of you has heard of smart contracts? Are they contracts? No. Are they smart? No. They're dumb. And just naming this example of smart contracts shows that in relation to a blockchain technology, you should be very careful if it really helps you or if it's just a facade for a window dressing compliance. And so blockchain technology, it has its uses, it might have its uses in the field of compliance, but in the end, its use is limited. Now, let's move even beyond the second degree to cybercrime compliance in the third degree, and that's something which lacks history in other fields. In relation to information technology, we have this phenomenon that information technology is insecure. Information technology can be misused for identity theft, for privacy violations, for defrauding people, and we have to address this problem of information technology insecurity. And it has proven that users are really bad at keeping their systems up to date, that users of information technology, they do not care about IT security. And therefore corporations are now more and more required, under threat of criminal or quasi-criminal liability, to secure their information technology against attacks by external hackers, or in other words, against crimes committed by third parties. Such crimes, they typically target the infrastructure of corporations at first, and there some sort of damage occurs. For instance, an information leakage. Some corporation is hacked and all the credit card data stored with the corporation is leaked. Then the first damage occurs to the corporation. But later on, this data which was stolen is then used to commit further crimes, and that is when the real damage occurs. And now, by such compliance provisions relating to cybercrime compliance in the third degrees, corporations are required to keep their information technology secure, and if they do not do that, and an external attack occurs, then the corporation is held liable. Two examples for that. In Germany, a couple of years ago already, in 2015, a provision was enacted, and it requires internet service providers to protect their services by technical and organizational means against violations of the protection of personal data. That means against crimes attacking the confidentiality of these data stored at these internet service providers, and against disruptions even if these are caused by external attacks. And if corporations fail to provide such technical and organizational means, there is a sanctioning violation. It's only a limited punishment, just a financial fine, but still it requires corporations to be compliant in the form of keeping their systems secure against external attacks, against external crimes. And since last year, we have the same phenomenon on the European level. There is a provision in the General Data Protection Regulation which requires data processors to keep data stored with them secure against external attacks. And there have now been the first cases in Germany and in other countries where data processors have been sanctioned because they did not keep the data secure, and then external attackers could make use of that to commit crimes against the corporation and then against those whose information was breached. From an analytical perspective, this criminal compliance in the third degree is novel as it does not relate to risk resulting from within the corporation or directly attributable to it, but to risks resulting from external intentional misuse of devices or of services of the corporation. Such protection obligations are not unheard of. For example, owners of weapons are liable for an intentional criminal misuse of the weapon if they did not store the weapon securely. At least that's the case in Germany. But information technology, it's not seen as something inherently risky, inherently dangerous, such as weapons are. And so this is novel, and there we need to discuss the question of attributing risks and crimes of cybercrime. And we have the problem that so far we do not really know what is state-of-the-art in protecting against intentional crimes by third parties. What do corporations have to do to protect their services to avoid external attackers from committing crimes? And we have to we have this phenomenon. Who are the first victims of the crime? The first victims of the external attackers are the corporations. And it's a bit of blame shifting towards the corporation if we only focus on the corporation and not on the intentional attacker, the external attacker. And therefore, it's highly problematic if corporations get punished more strictly for failing to keep their systems secure in relation to the attackers which intentionally caused the actual damage. In the end, however, it's something we have to discuss in our societies, in our digital society, where to attribute responsibilities, where to which risks we accept in our digital lives, and which risks we force corporations to address. And now to a fourth degree of cybercrime compliance. It gets even more away from this classic field of a risky corporation, risks within a corporation. This fourth degree relates to crimes between users. And it's most eminent in the field of social media. There, of course, social media providers offer a tool for communication between the users, and these forms of communication may be misused to commit crimes. And where do corporations now play a role, and where do compliance programs now play a role? At first, there were some attempts in Germany to hold corporations criminally liable if they fail to remove some illegal content from their networks in time. But in the end, this proved impossible. It proved too complicated to assert which specific manager is liable for failing to remove such a message from Facebook, from Twitter, etc. And therefore, Germany enacted a different statute on a so-called Netzwerkdurchsetzungsgesetz, a term which cannot really be translated into English and probably also not into Spanish. What does this statute mean? Each social media provider has to create a framework to receive reports on hate speech and other crimes published by users on their platforms. Then they have to create a framework to determine whether the posting violates norms of criminal law, and then to take action, to delete or block access to the posting, and hopefully also to report the wrongdoing to the authorities. And if corporations fail to enact such a compliance framework, which relates not to misconduct within the corporation, but to misconduct by users of the services of the corporation, the corporation will be held liable. So there we have a very clear and specific requirement for criminal compliance, not related to risks resulting from within the corporation, but related to risks resulting from the users. From a theoretical perspective, this does not really reduce individual criminal liability of the users who violate the criminal laws. However, the incentives to prosecute them is reduced. If their hate speech is removed instantly from Twitter, from Facebook, hardly any harm is done. The authorities may never know about this hate speech, and the positive effects of compliance are followed on the spot. The message is removed, maybe the user is prohibited from using Twitter, Facebook for the next 6 months, and then we also have some sort of sanctioning. So it's a sort of even privatization of criminal justice, and instead of a proper criminal justice, we have some sort of proceduralization and a form of regulated self-regulation where it's the purpose of enforcing hate speech crimes is not put on the state but on private entities, which then have their private guidelines, such as Facebook, on what content is allowed, what is not, and the related problem that this is not in compliance with national hate speech laws. And in the end, such a privatization of criminal justice and an involvement of internet service providers in investigating and prosecuting crimes committed by users may also seen in a very new development on the European level, the EU Commission proposals on a European production and preservation order for electronic evidence. According to these proposals, authorities may request electronic data from Twitter, from Facebook, relating to a criminal investigation. And then it's up to the internet service provider to decide whether to follow this request. And it's not some sort of mutual legal assistance procedure, but it's a direct contact between authorities in one state, let's say Spain, and Facebook Ireland. And Facebook Ireland then will be able and will be obliged to check the validity of this request, and then even have to check whether this request by Spain manifestly violates the Charter of Fundamental Rights or is manifestly abusive. That's an inherent topic of for the courts. It's not a matter for internet service providers to decide whether something is in compliance with the Charter of Fundamental Rights, whether a criminal investigation is manifestly abusive. Here we have again a privatization of criminal justice, which relates to crimes committed by users, and internet service providers are put in a position where they have to create a framework for compliance, here a compliance in the fourth degree. So to come to some sort of conclusion, we have an involvement of criminal compliance in the field of cybercrime from 1.0 to 4.0. But corporations in the field of IT still have to do 1.0 compliance, 2.0 compliance, and nowadays even this compliance relating to crimes committed by users or between users. And we should be very careful about this shift of power to corporations. Criminal compliance at first was about limiting the power of corporations. We had this issue of multinational corporations which needed to be brought back under control of democracy, under control of states, under control at least of the European Union. And their criminal compliance of telling corporations, of forcing corporations to do something themselves was a very useful tool. But now, criminal compliance in the field of cybercrimes is used to give more power to corporations, is used to shift responsibilities away from the state to corporations, to the detriment of democracy. The guidelines for Facebook, they have no democratic background. They have a background by Mark Zuckerberg. And so we should be very careful about this shift. It has its uses, but it also has its risks in relation to the rule of law, in relation to representation, democracy, in relation to the goals of criminal justice. Thank you very much for your